This program provides a brief summary of diversion and non-custodial sentencing in South Africa. This program covers the following topics: the criminal justice process in South Africa, types of diversion, the purpose of diversion, diversion and criminal records, psychosocial assessments for diversion and non-custodial sentencing, managing non-compliance, reporting, NICRO service statistics. The criminal justice process in South Africa. Diversion takes place after arrest but before a matter is set down for trial. Offense is committed. A case is opened. An arrest is made. The docket is sent to the prosecutors. Most diversion takes place here. The matter is set down for trial. A plea is entered, guilty or not guilty. The trial commences. The trial is finalized. Diversion can still take place here. A verdict is reached, guilty or not guilty. Case is set down for sentencing. A sentence is passed. What is diversion? Diversion is intended as an alternative to the conventional criminal justice system. In South Africa, children are diverted in terms of the Child Justice Act. At present, there is no specific legislation that sets out diversion for adults. Despite this, many adults are diverted. Most diverted cases are diverted before a case is set down. Very rarely, a matter is diverted after a trial has been conducted and the case finalized. So long as sentence has not been passed, diversion is still an option. This option is very rarely used. Here, the judicial officer will decide to divert. In NICRO's experience, all cases where this option has been used have all resulted in the matter being stood down as the accused is regarded as a child in need of care. The original offense is diverted, and the child is sent to the children's court. Types of diversion. In South Africa, we use prosecutorial diversion. This means that prosecutors decide if a matter will be diverted. There are other types of diversion used in other countries. Police diversion. The police decide when to divert a matter. Judicial officer diversion. The judge or magistrate decides when to divert a matter. The purpose of diversion. Diversion is intended as an alternative to the conventional criminal justice system. The goal is to give a person a second chance and to avoid putting the person before the court. People who are diverted do not get a criminal record. Instead, they are sent to a service provider to go through an intervention as per the diversion recommendations. When they have successfully completed their required interventions, the matter is closed. People who are diverted do not get a criminal record. However, a number of people have brought a problem to the attention of NICRO. It appears as if the court documents sometimes contain errors, which results in the offender being recorded as having entered a guilty plea. This results in the offender being found guilty without trial. They discover they have a criminal records at a later point when doing a criminal clearance check, normally for employment purposes. As far as NICRO can work out, this seems to be a clerical error, which is then carried over and reflected in SAPS's criminal records database. To correct this, the offender must go back to court and inform the court clerk of the error. The court clerk then makes the necessary changes and writes to SAPS to correct their records. This can take several weeks to a few months. For this reason, we urge you to ensure that all people diverted under your care are informed of this, and are required to keep copies of their records for future purposes. Non-custodial sentencing. Non-custodial sentencing, NCS, is an alternative to prison. An offender has been found guilty by the court. Instead of going to serve their sentence in prison, they serve it in the community. Specific conditions are attached to their sentence, which is generally suspended. These conditions will include the interventions the person must attend. If they do not attend these interventions, they are breaching their sentence conditions. This diagram shows that NCS becomes an option after a case has gone to trial and a conviction has been delivered by the judge or magistrate. The care then moves to sentencing. It is at this stage that a client can be referred to NICRO for an NCS assessment. Assessments. NICRO conducts assessments for both diversion and NCS. The purpose of the assessment is to ascertain if the offender is suitable for NICRO services. Once an assessment has been conducted, the caseworker writes and submits a report to the prosecutor. This is the case for both diversion and NCS. At NICRO, assessments may only be conducted by a social worker or a psychological counselor. Our standard is to conduct an assessment over a period of days in order to obtain corroborating information from the victim, family, school and other relevant structures. This is preferred in order to obtain as much information about the offender as possible, so that the assessment makes sound recommendations. The assessment is a psychosocial assessment that looks at the following: the offender's risk factors, the offender's protective factors and the offender's responsivity factors. Risk factors have been identified in the literature as having a known direct impact on increasing the likelihood of the person committing further offenses. In brief, these risk factors include, but are not limited to the following: attention deficit or hyperactivity, conduct disorder, genetic factors, hazardous alcohol consumption, involvement in violence, lack of pro-social leisure activities, low academic performance, low intelligence, mental health problems, lack of employment stability, poor values, attitudes and beliefs, poor work performance, sex, being male, substance use and abuse, victim of child abuse or neglect. The more risk factors a person has, the higher the likelihood they will commit another offense. Protective factors have been identified in the literature as having a known direct impact on decreasing the likelihood of the person committing further offenses. In brief, these protective factors include, but are not limited to the following: good academic and work performance, good communication skills, good conflict management skills, good risk management skills, high levels of contact with pro-social peers, participation in pro-social activities, self-mastery, personal agency, and coping strategies, strong anger management skills, strong problem-solving skills, temperament, caregivers actively involved in schools, family dynamics stability, financial stability, pro-social caregiver values, attitudes and beliefs, strong bonds or relationships with neighbors. The more protective factors a person has, the lower the likelihood they will commit another offense. Responsivity factors have been identified in the literature as having a known impact on a person's ability to participate in a behavior change intervention. These include, but are not limited to, disabilities, including learning disabilities, language issues, developmental issues. The responsivity factors need to be identified and factored into the recommendations made. Specialist areas. The assessment also identifies areas that may require a specialist to conduct a further assessment. Examples of when this could occur include: the offender presents with possible mental health issues. The offender presents with possible undiagnosed disabilities. Organizations like NICRO cannot assess these areas. These areas can only be assessed by a psychiatrist, a doctor and similarly specialized professionals. If, during the assessment, indicators are found that demonstrate the likelihood this person needs a specialist assessment, the caseworker will include that in the recommendations. Reporting. Both diversion and NCS involve multiple reports being made. The diagram to the right maps those out. In addition, the referral source may also request interim progress reports. Non-compliance. Managing non-compliance in diversion and NCS is an important part of ensuring impact and quality services. This section will show you how NICRO defines and manages non-compliance for both diversion and NCS. NICRO defines non-compliance as one or more of the following: the offender does not attend the required interventions. The offender attends the required interventions, but does not participate. The offender does not attend the required interventions because they have been detained for a historical offense. We will look at each of these in more detail. The offender does not attend the required interventions. Here the offender does not attend the required interventions without a valid excuse. NICRO requires doctor's notes and similar documentation in order to validate an excuse for absence. NICRO typically counts 2 or more missed sessions without a valid excuse non-compliance. The offender attends the required interventions, but does not participate. This was added into NICRO's non-compliance management process at the request of staff. The reason for this definition is to ensure that everyone takes full advantage of the behavior change opportunities being presented to them. If people can simply be physically present without engaging, this will result in people technically complying with the diversion or NCS order, but not making any observable changes in behavior. The whole point of NICRO's services is to change behavior. Requiring people to participate in discussions and activities can act as a catalyst for disengaged people to be compelled to participate. Once participating, we generally see improvements in people's behavior. Therefore, non-participation will elicit a response from the caseworker. The offender does not attend the required interventions because they have been detained for a historical offense. We differentiate this from simple non-attendance, as the client's absence is not necessarily a reflection on the client's current behavior and state of mind. Responding to non-compliance. The process NICRO follows is set out below. Contact is made with the offender to ascertain the reasons for non-compliance. The offender will be afforded opportunities to make up missed sessions. Detailed notes are kept in the case file under Process Notes. If the offender continues to be non-compliant, or they are detained for a historical offense, the caseworker will submit a report to the referral source, which sets out what occurred and what steps were taken by the caseworker to communicate with the offender. The prosecutor must then take the matter forward. The prosecutor responds as follows. Diversion. The matter is generally addressed by issuing a warrant for the offender's arrest. The prosecutor then sets the matter down for trial and proceeds. NCS. Non-compliance means a sentence condition has been breached. This is dealt with as per the established court processes for breach of sentence conditions. Diversion non-compliance implications for trial. An offender must take responsibility for the offense in order to be eligible for a diversion. This does not mean the same as a guilty plea. A guilty plea can only be entered at a later stage in the court process, after a case has been entered on the court roll. It is important to remember this distinction. If a diverted offender is non-compliant and their matter is then set down for trial, the diversion process undertaken to date has no relevance for the trial. NICRO service statistics. The most common offense NICRO uses diversion for is theft, followed by assault with the intent to commit grievous bodily harm and common assault. The most common age groups NICRO receives referrals for are youth aged 18 to 35, and adults. Most commonly used interventions. For both diversion and NCS, the following are the most commonly used NICRO interventions: adult or youth life skills, substance abuse prevention, and anger management. Here is a full list of NICRO diversion and NCS interventions. Study this table, which summarizes the main similarities and differences between NCS and diversion. How to make a referral to NICRO. Speak to your nearest NICRO office for the details of the caseworkers who can assist your court. Click here for the contact details of your nearest NICRO office.